Hi everyone, I'm immigration lawyer John Khosravi. Thank you for joining today's Q&A, 5 p.m. Pacific, Monday through Friday, discussing U.S. immigration law and helping to give you information on what's going on in the field of and world of immigration law, as well as trying to answer your general questions. To start, if you're watching this on YouTube, please press like and subscribe to this and press the bell to get updates. This long video will have clips of it for the best part, the most meatiest part, piece of information that people ask about. So let's get updates on that by subscribing on the YouTube channel. You can also find us live on TikTok, Immigration Lawyer John, Monday through Friday, 5 p.m. And that's where a lot of people post their questions. And thank you for joining on TikTok. The handle is Immigration Lawyer John, John, as well as on Facebook Live. JQK Law Firm is the handle there. A lot of this information will also be on the Instagram page and the LinkedIn page for JQK Law Firm. And if you wanted to email me to set up a consultation, my email is info@jqqlaw.com. Please note that fees do apply, but email me and describe what kind of immigration issue you have and we could take it from there. So before taking questions as people are trickling in, I wanted to talk about 2 points, legal updates that could help a lot of people. The first thing is there was a closing of the border for entry of people from Mexico and from Canada. Because of COVID-19, the scare and the fear that exists, the borders were shut down with exceptions, and this was renewed again. And so I wanted to give some information about what these travel bans are from Mexico and Canada. Now, first and foremost, you have to understand that it's only for people coming to the U.S. by car or by ferry. It doesn't go to airports and stuff like that, so those travel bans don't exist. It's if you're coming at a land port of entry, driving in or trying to walk into the United States. And there are exceptions to this, so it's only essential travel that could come in. And what do they consider essential travel? It's people who are U.S. citizens and lawful permanent residents returning to the United States, individuals coming for medical purposes, individuals traveling to attend educational institutions. So if you're an F1 student visa holder, for example, you have a student visa, you can come back in. It's considered an essential worker. They have a general category that says individuals traveling to work in the United States. And the examples they give are agricultural, farming kind of people. I would assume this includes TN NAFTA visas and people on H-1Bs, general work visas, because it says individuals traveling to work in the U.S., and those work visas would come under that. Also, individuals traveling for emergency response to public health, people in the military and their family members, individuals engaged in lawful cross-border trade like truckers, and diplomats and the like. So those are the people that are considered essential people that are coming to the United States, that are doing essential travel, that are exceptions to this travel ban from Canada and from Mexico of coming from a land port of entry. But those people not part of the exceptions, those people that cannot come in, include individuals traveling for tourism purposes, and the examples that they give are sightseeing, recreation, gambling, or attending cultural events. So this does not include people going by air, by freight, rail, or sea travel to the U.S. From Mexico or Canada. It does apply to passenger rail and passenger ferry and pleasure boat travel. And is this going to be continued until June 2nd at least? They could make it longer. They could add a longer time to that. We'll have to see. They allow that amendment, but for now it's till June 22nd for this specific travel ban from Mexico and the U.S. From a land border. So that's the first topic I want to talk about, was this travel ban from Canada and from Mexico. The second thing that's very important to a lot of listeners is the updates to the visa bulletin that were released yesterday. So let me give you a heads up what the visa bulletin is. If you're applying for an employment-based or a family-based visa, that's in the preference category. So essentially the lines that they are for green cards, except for people that are married to U.S. citizens, parents of U.S. citizens, or minor children of U.S. citizens. There's a line that emerges, a family-based line and an employment-based line. And every month, the Department of State updates where you are on this line. So when you submit the initial application, they give you what's called a priority date, and that's your place in line. And you check this visa bulletin every month to see what visas are being processed that month until your priority date, the date where you submit your application, shows up as to the type of cases they're handling at that time. So right now, if you look at the family-based categories, there's 2 charts. So let's break it down a little more to make it more complicated. There's a chart when they could actually issue the green card, print it out, but there's a second chart in there that says when they could start accepting paperwork to begin the processing of your case. So the first chart, when they could actually print the green card out, is called the final action date. The second chart, where we could start submitting documents, is called the date of filing chart. Now, the National Visa Center or the Department of State, when you're outside the United States processing, they go by this. So they'll start accepting documents by the date of filing. and then final action days when they could actually issue the green card. But if you're in the United States, whether you could use a date of filing or not, the sooner date that allows you to just submit the paperwork in the meantime and wait out the process in the United States, that changes. And USCIS, the immigration office in the United States, updates that every month on a website on their website, on a page on their website. I know this is getting kind of complicated, and this is why I sometimes need an immigration lawyer to check on this stuff for you. But to give you a heads up, things that move forward in the family-based category, final action dates have moved up by 2 months in most F1 category. These are adult children of U.S. citizens. The F2A, spouses of green card holders and minor children of green card holders are current, so they could start the process and get the green card. F2B, adult married children of U.S. Of green card holders, that came up 2 months. That moved forward 2 months. F3, adult married children of U.S. citizens moved up a month, and these are old countries. So there's if you're from China, India, Mexico, Philippines, sometimes the timelines are different. You got to visit the chart. I'm saying most countries in general have this kind of situation. And so there's been some movement forward. Now, there's been no movement forward on the employment base. So that's the interesting thing that popped up for the EB 1, 2, and 3 categories. So have a heads up on that. Except actually, when I say there's no movement, there's no different in movement in the date of filing. That stayed the same. But the actual employment-based final action date has moved up, and this is very important, especially for Indian citizens because they're so backed up. The EB1 category moved up 10 months. So that's really important. It's now June 2016. If you started your EB1 case in June 2016, the green cards are now available. In the EB3 category, we also had a 10-month jump in the general EB3 category, which has seen a big backlog. So if you're in the EB3 category, you know what I'm talking about. You saw that retrogression that happened, that jumped back the cases 3 years. Well, it went back 3 years, just came back 10 months. And so when people ask about timelines, it's really hard to say because all of a sudden one day the line goes long, it goes back 3 years, and then one day it goes 10 months forward. It's all over the place. Sometimes 3 months forward, sometimes a day or a week forward. It's all over the place. That's why you have to always check these charts, the Visa Bulletin, to see where your place is. And sometimes the immigration office doesn't notice where you're at. So what happens is they don't even notify you. So it's good to keep an eye out on there and contact them if they're snoozing, if they're not paying attention to your case. And hopefully you have an immigration lawyer to contact with that can help you with that process, especially for these employment-based cases that could take a long time. There's retrogression. There's all this messed up stuff that happens. So that's just some general information I wanted to share. It's a little complicated at times. You got to see what processing you are, what type of case it is, where you are, if you have any inadmissibility issues and the like. But having said that, let's start with the Q&A. Thank you so much for everyone for joining. Let me back up to see what I missed. A gentleman, how do not ask, what about J1 visa? What about J1 visa? J1 visa could be an educational thing, so it might be something in between if you're talking about the travel ban that I talked about from Mexico and from Canada. But if it's what about some other kind of question, let me know. You have to be more specific in the question that you're asking. Immigration Lawyer Momita, thank you for joining. A great immigration attorney in the East Coast. If you're a fan of this page or watch this Q&A, try to find her name, Immigration Lawyer Momita, M-O-U-M-I-T. She has a great page. It's really booming. A lot of great information. I really suggest you follow her as well. Let's see what else. So awesome to see you. Harid, you're welcome. Thank you. So the people are trickling in. Please let me know if you have any questions. Just throw them out there. Thank you, Immigration Lawyer Momita. I appreciate it. You're a great attorney and a good friend. Thank you so much for the love times one. And is that a guy hitting a baseball or something like that? That's good. You're welcome. You're welcome, Movida. So yeah, the Visa Bulletin is such a complex thing. It's such an annoying thing that there is, especially there's two charts. They try to make it easier, but they make it harder, make it more complicated. But things are somewhat moving forward in many categories. And that's the important thing. Immigration system's opening up. There's a potential that some cases they're even waiving interviews if an interview is required. And potentially, I heard through the grapevine that they're potentially just going to do interviews by video, like a Zoom video kind of thing. So if that happens, it's going to be very interesting because all of a sudden, you don't have to show up to a place. I love it because I live in Los Angeles. There's a lot of traffic in Los Angeles. When I have to go to an interview, sometimes it's in the sometimes in the morning, so I have to wake up early to go there. Wait 3 hours for our turn. By the time it's our turn, we get out. It's rush hour, and there's always rush hour in Los Angeles. And it takes me another hour or two to get back home. It really kills the whole day just to go to an interview. So if we could do it by video, woo, that'd be great. And it's less coronavirus risk, so that's always a good thing. They had a question pop up. What is a V visa? A V visa doesn't get used that much. I think a V visa was back in the day when processing for certain kinds of cases took too long. You could have got a V visa to kind of come to the United States and wait it out. I think that's what a V visa was. It hasn't, no one's ever used them for the last like 20 years or so. But back in the day when processing times were a little longer for certain family-based cases, they would use a V visa. And I can't remember exactly because I haven't seen one in many years. So just go to uscis.gov or go to Google and type it out. You'll get some information there. But if that was your question, that's what I think it was, but don't quote me on that. Forever Gone asks, if a father applied for his daughter and he passed away, I'm sorry about that. So if you have a case where a person files an I-130, a family-based green card petition for another family member, and the case is pending and that family member, the U.S. family member dies, the case disappears. If that case, the I-130, is approved and then that person passes away, if there's other close relatives and you ask for humanitarian reinstatement, it's a thing called humanitarian reinstatement, you could have that other family member take that person's place if they approve it and finish the processing. USCIS.gov, the website for the Immigration Office, has a great page that explains this. It has the relatives that could be part of it. And it's one of the only places where you can use in-laws for it, like a sister-in-law, brother-in-law, or parents-in-law thing. So it's a very interesting program that there is. It's not guaranteed that's gonna work. Sometimes you send it, it takes years for them to even review it. But if you have no choice, that may be the option to use humanitarian reinstatement. I think that's what it's called. I'll have to double check after we get off this. But they let someone take their place, but I think it's the I-130 has to be approved. It's not something I typically do, but you know, gotta know everything. So that's a thing that you could potentially try out. Okay, let's see. Forever Gone, he wanted me to continue. I'm a U.S. citizen. Yeah, I hope that works out. Look into humanitarian reinstatement or schedule a consultation with a lawyer to talk with them about it. Harid, a regular, asks, country cap didn't work for EB3. Why is it safe for all country? I'm from Nepal. I'm not sure exactly what you mean, but EB3 did move forward a little bit. So that there are country caps for different countries. For Nepal, it doesn't work, but their EB3 category, as I spoke about earlier, did move up 10 months. So it's not a bad thing. If Forever Gone, you're in the USA now. You have to be in status, so I got to see what kind of status you are in. But other than humanitarian reinstatement, what I recall, there's another program, 204L or 204. There's another program if you're in the United States already, as opposed to humanitarian reinstatement. There's another one that exists that I keep here, but I think you have to have valid status. I can't remember the details exactly. I think it was 24L or something like that. But I would say consult a lawyer. They could do the backup research. Remember what exactly the program is to let you come and get your status if a family member passed, if you have someone to substitute them. I just can't remember the exact details of it, but there's a program like that exists. So there is some hope, and especially if you're in the U.S., I think that the chances are higher you get approved for it. You know, for Gone, it's not a case I specialize in. I have to have a consultation with you to spend time, look for it. It'll probably be an hour consultation, so it's more expensive. But you know, email me, remind me what's going on. I'll let you know how much the consultation fee is, and we can take it from there and give it a shot. But just email me at info@jqqlaw.com, and we'll look into see humanitarian reinstatement or the other thing. I just can't remember the name. You know, it's 204, something like that. It was a number and then a letter at the end of it. And it had a 2 in there, I think, started with. But that's what we will look at, and then judge your family and life situation, so to see if there's a relative that could take their place, and also then the financial aspects of an immigration case, which is the affidavit of support from the U.S. person to show they're working, making money, or have a lot of assets, and then your background, which is new. This is the public charge rule, to make sure you are not going to be a public charge. So your income, your money situation, your health situation, your health insurance situation, whether you have a degree, how well your English is, all this kind of stuff. And you say, my sister has 5 kids, she's suffering in Yemen. So I got to see the whole situation. Forever Gone, I'm sorry to hear about all this. Is horrible, and just getting someone here from Yemen is really hard. Just because of, you know, embassy shut down, so they have to go to Africa for an embassy interview. It's a terrible situation. Another problem with Yemen is they don't always have documents. I have Yemenis clients. I know they don't always have birth certificates. It's hard to get one. Marriage certificates, death certificates. It's not official documents all the time, and especially because of how war-torn the situation is, it becomes really hard to get documents. But so there's a lot going on. If you have a Yemenis case, if you have the petitioner died kind of case, all this kind of stuff we have to look into to see what's going on, and then give it a shot. That's the best I could help you out here. But thank you for your question. I appreciate it. So we had a good group. Wow, it jumped up. Let's see. Let me see if I missed anybody. Rocky asks, if we withdraw an asylum case, can we get bond back? Well, you don't post a bond when you do asylum case. If you're in immigration court, that's another thing. And I don't handle immigration court cases and bond and stuff like that. I only handle cases where people are not connected to the immigration court yet, or they don't need to go there. So I don't deal with bond too much. I'm not a good, word of advice on bonds and stuff like that. I would suggest contacting some of the other guys. Immigration Momita has more court experience than I do that I talked about earlier. She would be a good channel to connect with to see if she could help you out on that. And part of those things, if this is a court thing, you might want to hire a lawyer and because someone's local that can help you because they may need to go to immigration court. So that's that. Thanks for everyone. So yeah, for now we gotta schedule a consultation to get into it. User 32 asks, can a chef apply for a USA green card? So actually, a chef has a lot of options, but they have to be a really good chef. So they have to be a really kind of famous kind of chef. So first of all, chefs could come in under O1 visa. These are people with extraordinary ability coming to do a job in the United States. So potentially, if they have awards in their names, if you have articles written about them, they make a lot of money, they're famous, they just have a lot of success. They can apply for the O1 visa, come here and work, and it's a great visa because it bypasses the H1B. You don't have to have a degree for it. So there's a lot of good, easy ways to do it. It's gotten harder. USCIS has gotten more strict on O1s than they used to be, but it depends on how successful you are as a chef, and you could come. So that's not a green card. That's a temporary visa to come that gets renewed for you to stay and continue working here. And you can bring your sous chefs too. It's interesting, and your spouse, and just stay here and work in the United States. So it's an interesting visa. If you want to get a green card, you have to apply for the EB-1A. Now you could apply for different kinds of green cards. You could invest, you could get hired and have an employer hire for you. So I'm saying very specific kinds of things. The EB-1A, the cool thing is if you're really great at what you do and you can show you're one of the best, you can file for it yourself. You don't need to have a job lined up even. So you just say, I'm gonna come to the United States, I'm gonna continue being a great chef, but here's my awards, here's my articles, here's the money I made, here's the thing, this and that, just how great I am, and then you get a green card, and that's that. Now there is the EB-2 and the EB-3 employment-based categories, and those you need to have an employer file for you. For example, some restaurants, a Thai restaurant, I've seen a lot of these. I used to work for a firm that did a lot of these. A Thai food restaurant needed Thai chefs to come to the United States. They applied for a bunch of EB-3 green cards. They said, we don't have enough Thai chefs that don't understand the cuisine as well. And we got a bunch of people at the old firm. I don't do these kind of cases myself anymore, this particular kind of case, but we brought a lot of people from Thailand over to work in these Thai restaurants across Los Angeles, a chain of these restaurants. So it was a spectacular thing to do. So chef options are there. You got the O1 for temporary, EB-1A if you're great, EB-2 or 3 based on employment and education, that kind of stuff. EB-5 if you come here, start your own restaurant, invest a bunch of money and create a bunch of jobs. There's EB-5 too. Depending on what country you're from, you can do an E2, which is not a green card, but you come invest. And depending on what country you're from, start a business, start a restaurant potentially, and run that restaurant and just stay here while it's operating. And who knows, in the meantime, while you're here, you fall in love with a U.S. citizen, get married, and get your green card based on a relationship like that. So things like that are possible. Love is in the air. Just get yourself here. Go to Match.com, go to these dating websites, and as long as it's genuine, you don't want to do a fake relationship. That's illegal. But if it's a bona fide relationship that works, or just work really hard, so everyone knows how great you are as a chef, have articles written about you, win awards, and then you can maybe do the O1 or the EB-1A, or you get so famous that some famous restaurant in the US wants to hire you, bring you here, and they apply for your green card. So these kind of options do exist. It happens all the time. I've seen it happen all the time. Now there's a lot of chefs in the world. There's probably a million chefs in the world, if not millions. Very few of them could do this, but the very few that could do it, I've seen it happen. So it's doable. I don't know you, I don't know anything about your background, but I would say if you're not there already, really work hard, be the best at what you're doing, and the U.S. will with open arms accept you, even under President Trump's time. They love it. They'll have you come and it will help you out. The EB-1A category I talked about, they say the wife of President Trump got that too, based on being a model. I don't know the exact facts of it, but they say that's rumor she got that. This EB-1A is about extraordinary ability, how great you are. So if you're a great chef, I've gotten it for great business lawyers. I've gotten it for a lot of athletes, karate, jiu-jitsu. I've got it for comedians, singers, actresses, race car drivers, a lot of different things, artists. So, it just fills up. You're really great. We want you here in the United States. That's the goal of the EB-1A category. And that's one of the visa categories I love doing. So definitely look into that. It could be something that could help you out. Okay, let me bring this handkerchief out a little bit. You want to be seen. You got it. You show it. All right. So user 726 asks, can I apply for unemployment? Is it going to affect my green card? Probably not. It depends on a lot of different things. I need to consult with you to give that kind of individual advice about it. Usually unemployment will not affect your green card application, but there's little exceptions that could, and I don't want to give general blanket advice in this form and lead you down the wrong direction without talking to you, so I need to have a consultation to answer that. Monbas, my asylum case is in process. Now I'm married U.S. citizen, filed I-130 months ago. How long would it? So I need to know more information about how you enter the United States in this kind of case. So this person has asylum case pending. They're in a period of authorized stay. And they filed a marriage case, it's I-130, but you didn't say you filed the I-485. So I don't know if you could file I-485 or not, if you have to leave and come back in. There's holes in the information here that require me to sit and talk with you. So you should have contacted an immigration attorney 8 months ago before you filed your I-130. You may have messed things up a little bit, maybe, maybe not, but I would say consult with an immigration lawyer just to get down to the bottom of it, see what we can and can't do. My email is info@jqqlaw.com. The main thing is if you enter the U.S. lawfully, as long as you did that, then you'll probably be okay. But there's other factors we got to analyze here to figure it out. I really wish you had talked with an immigration lawyer 8 months ago. Was the perfect time to try to avoid the public charge rule if that's possible. So I would say call a lawyer and talk to them privately. There's a lot of nuances we got to deal with. Harid asks, why the November 8th, 2017 for every country, same date except India, China? Why is that different? Let me look at the charts really quick. So you're saying EB3 category, EB3. Yeah, it's November, where's the June? I have it here. So we're looking at the visa bulletin to see, this is the line that people have to wait in for different categories. And this is for June, I'm looking at right here. You're saying, why is November 8, 2017 for every country, every country same date except for India and China? Why is it not different for each? Let's see, November 8th. Why is it not the same for each? Everyone's got a different line. There's a different amount of people asking for a visa. So not every country has the same timeline. Some countries that use it a lot have bigger lines because there's more people in line, and that line doesn't move as fast. For example, in China, the embassies have shut down, so they're not processing Chinese visas, so that's really slowed down much slower than in the rest. So they don't always move at the same length forward, same timetable forward. And then asks, when will USCIS open for biometrics? They've said they're going to open June 4th, but we'll see. Just check uscis.gov, their website, for the latest information. User 458107 asks, hi sir, can a U.S. citizen sponsor his wife's parents? No, you can't sponsor your in-laws. A U.S. citizen can sponsor their spouse, their own parents, or minor children, as well as brothers and sisters and adult children that are married, but they cannot sponsor their parents of their spouse. So in this kind of situation, the U.S. citizen will get a green card for the spouse gets their citizenship then a few years later, and once they're a citizen, they apply for their parents, but no in-laws are allowed in the U.S. immigration system, family-based cases, so that wouldn't happen, unfortunately. No parents of spouse. BJ asks, I got a 693 letter, so how long to get an interview? Thanks. This is a question I get asked exactly the same every day. The I-693 is a medical checkup, so when you have a green card case pending, if you didn't submit the medical checkup with the initial application, they send you a letter that says, remember to bring the medical checkup with you in a sealed envelope to the interview that they're going to have, in-person interview with USCIS. How long does it take afterwards? There's no set time. It just depends on whenever a slot opens up at your local field office. It could be a month, it could be a year. There's absolutely no set time. One thing you could try doing is go to uscis.gov, the immigration department's website. They have some general processing timelines that are horrible and they're not very consistent and they're unreliable, but try going to that if you want some unreliable advice. I don't want to give you unreliable advice. I want to give you reliable stuff. So I'm not going to give you a guesstimate, something that's impossible to guess about, but try go to uscis.gov. They might give you some a better idea. User 458 asks, can I travel on a green card while I'm caught up on shoplifting charge case 2 years ago? So that's criminal history. That's something you need to have a private consultation with to see exactly what happened. So that's not something I want to answer in a public forum like this, but definitely consult a lawyer in private. Okay, BJ asks the same question. I'm going to ask, how does DUI affect my citizenship? Well, if you're already a citizen, it shouldn't affect. It doesn't make a difference. If you are applying for citizenship, if you have one DUI and you're in probation, you can't file until the probationary period is over. That's one thing. Some people say wait another 5 years after that to file. Some officers may be strict on it, so that does exist. If you have more than one DUI, recently they've gotten really strict, so they might not even approve it if you have more than one DUI. But it varies, depends on your local field office, what the situation with the DUI was. Did you hit somebody? Did you cause property damage? And just the officer that you're dealing with, how they want to analyze it and judge it. And so there's a lot of factors that go into it. If you have criminal history, you always have to 100% talk with the immigration lawyer at the very least. Probably should have an immigration lawyer with you on the case. So, hang up the phone right now, call an immigration attorney. As much as I appreciate asking a question here, it's not a good place to ask personal criminal history kind of questions. That's a private conversation is needed for that kind of stuff. I am Kravazanas asks, also, what happens with me if I got rejected after my answer on RFE? So if you filed a request, so sometimes the government, USCIS, you file a case and are not happy with your response, they want more information. And it was called a request for evidence, an RFE. If you submitted that RFE and they didn't like it, they denied your case, then you're denied. And what you can do afterwards depends on what underlying status you have, what the reason for the denial was. If they're accusing you of fraud, that's a very serious factor. If you forgot to give your birth certificate, that's another thing. But there's other things that go on. So there's a lot going on there. This is not a question that can be answered here. This is something you got to sit and talk with the lawyer and analyze for a proper response. All right, Kristen asks, if my husband have asylum status after I get approval marriage status, I have same status with him? I don't understand your question. If your husband had asylum status, so SILE, after I get approval marriage status, I'm not sure what you mean by approval marriage status. There's no marriage status. So there's a lot going on. Either rephrase it or schedule a consultation so we can analyze what's going on with your question. There's a lot of things I have to consider. Krush asks, my fingerprints fee received for change of status to B2 to student is approved or will it be rejected? Oh, the fingerprint fee received is just the accept the fee, so it has nothing to do with your underlying case. Whether you're B2 to F1 will be a 2B2 to student. Are you saying you're going to a B2 tourist visa or are you going to a student visa? So you worded it kind of bad. If you're going to a student visa, your biometrics has nothing to do with the underlying case, so I don't know if it will be approved or rejected. But it's a very tough thing. When you want to change status to a student visa in the United States, there's a lot of things that have to happen perfectly. So hopefully you hired a lawyer to help you on that, because if you didn't do an extension B2 in the background, if your school's not starting at the proper time, your I-20 can't be moved around. These are kind of technical things I'm saying. It's confusing, and it is confusing. You should definitely consult with a lawyer in private about this to make sure you did it right so you don't go out of status by mistake. It's me. Nana asks, how can someone get a green card with a second deportation? Well, that's going to be very hard to do if you have 2 deportations. You have to have very exceptional circumstances. I don't handle those kind of cases, but you got to talk with an attorney in private to see if some sort of exception exists. That's rare. Unfortunately, 2 deportations is just pretty nasty. I'm not sure if that's going to happen. But talk with a lawyer in private. User 726 asks, I have an asylum case that's pending. Should I apply for unemployment? If you had a work permit, you had a work permit, you weren't working unlawfully, and you lost job, then and you abide by your state regulations, yeah, you could apply for unemployment in that kind of situation. If you had a work permit and you're unemployment, because getting unemployment or not having a job, the financial aspects or public charge issues don't usually apply for asylum cases, and that's why you're in a unique situation. So if you're other people listening to this and you're thinking like, should I get unemployment or not? This is a specific fact pattern that I'm giving this answer to, because public charge things don't apply for asylum people. So that's that. Now, unemployment generally is not a public charge issue, but there's other nuances you want to be careful of, and that's why I don't like publicly talking about unemployment benefits without knowing someone's full situation. Din asks, my husband is waiting for an immigration court appointment. Would it hurt the case if I lent affidavit? I don't know what you mean if you lent an affidavit. There's no lending an affidavit. I'm not sure what you mean. So just talk with your husband's lawyer. He should have an immigration lawyer if he's going to court. Ankush asks, Asylum approved 2014. When can I apply for naturalization? I think I asked a question before, the same type it was before. Well, if you have asylum, you can file for a green card 1 year after getting asylum status. So once your green card is approved, the green card will be backdated by 1 year. So once you get your green card, around 3 years and 9 months, or between 3 years and 9 months, 4 years afterwards, you could potentially apply for citizenship if you have an asylum-based green card. Now, whether you could file it after that time, it depends on a lot of other factors. You got to look at your continuous presence, your physical presence, your good moral character, tax payments, underlying status. Did you lie about your asylum case? There's a lot of things that you have to go look into to see if you can file for citizenship. But purely on the basic timeline when the first date is that you can file, it's 4 years after you get your green card because they backdate the date 1 year. Or if you've been married and living with a U.S. citizen, once you get your green card, maybe 2 years and 9 months. So there's different things that are working out. I need to know more about you before I could give a specific kind of answer, but that was some general stuff that hopefully helped you out. Jasper asked, when they reopened Mavni, or are there still programs to this? So Mavni was a program that was created to help foreign people come to the United States or in the United States, join the military, and through that route become U.S. persons, get citizenship. President Trump came in and said this is a dangerous program, we're going to shut it down. And so far, right now, it's essentially been shut down, M-A-V-N-I, Mavni. Here, Jasper asked, so what's going on with that program? We don't know. We'll see what happens. There's lawsuits. There's people caught up in this. There's people from China that joined it. They can't get their citizenship, but now they can't go home. If you go to China after saying, I'm going to join the U.S. military, that's a very dangerous thing to go to. So maybe they file for asylum at that point. I don't know. Unfortunately, Mavni is not working out right now. We got to look at your case in particular, see what's going on. It seems like there's no alternatives during this administration. We'll see what happens afterwards. I am Khosravi. We're reaching the end of the show, so I want to take 1 or 2 more questions, and then tomorrow, 5 p.m. Pacific, we'll be back. Join us on YouTube. If you go to my profile page on TikTok, there's a link tree that has links to my various social media. There's Instagram, there's Facebook, there's YouTube. Click and follow on all of them because a lot more information is going to be there. I post approval notices, samples of my approvals, so you get a general idea what timelines are in certain locations, and I'll help you out to just go there. So I'm going to answer this question and 1 more, and that'll be it for today. I am Khosravi. Nanzas asks, after how long can I apply for citizenship if I'm marriage-based green card in California? Well, it depends on your spouse. So if your spouse is a U.S. citizen, you've been married to them for the last 3 years. So if you've been married and living with a U.S. citizen for the last 3 years, you can apply for citizenship at the 3-year mark. But if not, 5 years. And that's the general answer to that. At least 5 years, at least 3 years. And Deanna asks, my husband is waiting for an immigrant court. We've asked about that already. In case if I lend an affidavit. I don't know what lending an affidavit means. R. Fines asked in the last question, more or less process after I-130 is approved by USCIS? More or less, this is a conversation when you have, so that's not a question I can answer. And so, Dana, again, you're asking this question, if you give an affidavit, what does that mean, giving an affidavit? Are you talking about affidavit of support, a personal affidavit? You need to talk to a lawyer in private to see exactly what you're talking about there or what you mean. It's not something I can help you with right here. But that's it today. Definitely tune in tomorrow, 5 p.m. Pacific. I might go into what happens after you submit I-130 as an initial talking point before we start things. But no more questions. Thank you so much for joining. I'm John Khosravi. I'm an immigration lawyer, headquartered in Los Angeles, but I handle cases from across the country, everywhere, world, everything like that. I help people in all states, all countries, do it all the time. I love the immigration practice. I teach it. I talk about it all day. I train other lawyers. I help people. I'm all day immigration law. It's my thing. So I'm happy you all joined my show and everything like that. Please subscribe and follow more, and we'll catch you tomorrow, 5 p.m. Pacific, on TikTok, Immigration Lawyer John, and on Facebook Live. And the video will be here right on YouTube and on various other social media avenues. Thank you so much, everyone. God bless and be safe. Bye-bye.